I got some coffee. You ready? Okay. All right. So we talked a lot about the process. So now we're just going to talk about the, kind of my involvement more in depth on these types of cases. So our motto is to seek justice, comfort, closure, and hope for our survivors. I only have the district attorney's office, sex crimes unit only handles felony sexual assault. So you may have a lot of cases that are involving misdemeanor charges. And for that, in the county of LA, you can have the city attorney's office. That's a separate agency. They have different guidelines, different attorneys, but they handle the misdemeanor, and I handle felony. The difference is, felony cases, you're looking at state prison time. Misdemeanor, like she talked about, is usually county jail local time, and is usually not more than 1 year maximum. Okay, so that's the difference between the two. So one of the maybe first things you got to figure out is who's prosecuting the case. Is it a misdemeanor? Is it a felony? Who the DA is? Who the city attorney is? When you get involved with your victim. We already talked about the different places. The process. Again, we do arraignment, prelim, pre-trial, all the way up to jury trial and sentencing. The pre-filing interview. I believe you've had already some background or some training in this, but I touched up on it briefly before the break. But usually in a pre-filing interview for us, that is our time to evaluate the case. Do we have enough evidence? Do we think we can prove this case beyond a reasonable doubt? Is this somebody that's going to be able to articulate enough facts for us? Because sometimes we have people that don't remember anything that happened. What kinds of charges fit the scenario? Because again, not every case is the same. You have two rape cases, totally different results or totally different evidence. So we judge each individual case individually. We can't just go off of, well, I saw on TV this happened on this case, therefore the same thing should happen in my case. That's not what happens, okay? So every single case is looked at in that way. That's my time and opportunity to talk about the process, just like I have here with you. I try not to do too much overload because if you tell somebody all these things all at once, they're not going to remember. So we do our best to kind of tell them as we go along what's going to happen next, because we don't want to overwhelm them with information, okay? And I always tell them, hey, when you get in the car and you think of 10 different questions, feel free, call me. Here's my cell phone number, here's my card. Call me, text me, and we'll talk about your questions, okay? Always give them that option, because keep in mind, this is a lot of information that they might be overwhelmed. In our office, we have a victim advocate right there, so they're going to do your Victims of Crime program application, and I believe that will be part of your training if you have not already heard it. This is where the state pays for your emergency relocation funds, your counseling. This is your Victims of Crime program in the statewide. The filing decision, like I talked about earlier, I may decide we need more investigation. We might not file right away. We might decline the case. And we talk about what happens and why. Answer any questions and advise the victim of their rights. Okay, so that's basically what happens in a pre-filing interview. This is the ideal, okay? Because I know we talked a little bit about, well, that didn't happen in my case, or nobody told me that, or that when that happened to me. This is this is what we hope is happening in every single pre-filing interview, and that's throughout the state of California. I don't know, there might be a lot of cases that fall through the crack, but that's why you're here, to make sure that your case for your victim does not fall through the crack. Okay, so this is the standard that we hope is happening in every case. Victims' rights, I think we talked about it, but just legally, some of the things we haven't talked about is, in addition to having support people with you in the SAR examination, in the courtroom, in the court, you also have a right to confidentiality as a victim of a sex crime. That means that your name can't be out there in public so everybody knows, oh, there's that person that got raped, okay? We very strongly protect the confidentiality of that victim, so we never call somebody by their full name in court. We'll only refer to them as their first name with the first initial of their last name. So for example, I would be Gloria M. and not Gloria Marin. So we don't want somebody to know who I am. And it's the same for kids as well. So that's protected by the government code, it's protected by Marcy's law, and we, policy in our office is to protect that as much as we can. There are limitations with that, okay? I had a victim last week call me, she was very, very upset because her name, I won't even say her name here, let's say her name was Gloria M. And she does not want to come forward. We had a pre-filing interview, she's very afraid, doesn't want to come testify, and was very upset because she doesn't want her name, to be known to the perpetrator. Because we contacted her years later, after her case had already been declined. Here we are now calling her years later, and she agreed to talk to us for a pre-filing interview. We filed the case, and now she doesn't want to come testify at the preliminary hearing. Okay, so some of the things that we talked about was that she was very upset because we used her name and we had told her we weren't going to use her name, and so her understanding of that was that we were just going to call her Jane Doe, which we could have, but at the time of the pre-filing interview, we did explain to her that it was going to be first name, first letter of her last name, first initial of her last name, but somehow there was a miscommunication, and now she was really, really upset. Okay, but I think there was more stuff going on with her. She just doesn't want to go forward, and that's where we are with her. But be aware of that. Like, explain to your victims, hey, first name, okay? Unless you specifically don't want to be referred to at all, we can then talk about whether or not we can file it as a Jane Doe or John Doe, okay? We redact from all the police reports addresses and phone numbers, social security, driver's license numbers, etc. That again is part of that confidentiality. We don't, because a lot of these are public records. The police reports are public records. People can access that. We don't want to reveal that to the public or the perpetrator. So we do protect that, but there is a limitation. At some point, the defense attorney has a right to know who the complaining witness is. They have a right to investigate who that person is. So they're going to have to know the last name and contact information, okay? Because under Penal Code Section 1054, they're required to know prior to a hearing where the address, phone number, and name of the person who's going to test it, and date of birth. So be aware of that. There's, the limitation is the defense attorney and his team, meaning his investigator or her investigator, will have access to that information. So oftentimes in the pre-filing interview, I will warn the victim, hey, after I file the case, you might get contacted by a defense investigator or a defense attorney, and so we hopefully try to prepare her for that, okay? But like, it often happens, they forget, they get the call, and they talk to the defense attorney, even though I tell them you don't have to if you don't want to. But, that's part of that information overload, I think. So on the confidentiality, it's the defense attorney is under ethical obligations not to disclose that information to the perpetrator, especially if we think he's dangerous, but I don't control oftentimes what happens, but I know that they're not supposed to share that information with the defendant. So that's the anonymity, so that their personal information is not given to the suspect, but we do have to turn it over to the defense. We can get a criminal protective order so that when we turn over the name of that child or that victim, adult victim, we can say, hey, judge ordered the defense not to disclose their information to the defendant or anyone else. And we do that every single day to make sure that that's not happening. Obviously, the witness relocation, we talked a little bit about that. There's that emergency funds. The victim is not required to undergo any kind of psychological exam or polygraph test. I think that's maybe many years ago. I don't know why that's there, but it is there, right? We wouldn't do that nowadays. The AIDS and HIV test results, typically you won't get that until after preliminary hearing. Okay, so you have to have a judge find that this suspect, that there's enough evidence to go forward at a preliminary hearing before that victim can be notified if he has AIDS. Okay, he usually has to be. There can be a way to try to petition the court to allow us to have that information sooner, but it requires a motion and a judge to make that finding. Okay. And obviously we talked about the victim impact statement at sentencing, to be notified of any bail hearing. So oftentimes a bail is set at the arraignment. First, remember when we first go to court and they declare themselves not guilty, a bail is set. If they later want to reduce that bail or be released on their own recognizances, which is to be released just with a promise that they'll come back, the victim has a right to be told that they're going to make that request, so that she or he can be present and say, no way, judge, for this and that reason. Don't let him go, don't release him, or don't reduce bail. And obviously, they have a right in every single case, not just sex crimes cases, to restitution. Okay? Restitution is not pain and suffering money. Okay? That's what civil court is for. So you're going to have victims who say, okay, yeah, we talk about restitution. Do you want him to pay you any money for any loss? And they think, yeah, well, I want to be paid because he made me cry or made me suffer or whatever. That's not what restitution is. Restitution in criminal court is anything that they had to pay out of pocket for that is a result of the crime. So medical bills, counseling bills, that kind of stuff. Loss of wages.
What about legal?
Legal fees could be a restitution.
No, you just said loss of wages.
Yeah, loss of wages, coming to court, parking for court, that kind of stuff. There is an exception to the pain and suffering for restitution, and it's very specific. It's only for our 288 crimes, which are our minor under 14 crimes, right? So any sexual contact with a minor under 14, it's a child abuse, child molestation, you can get pain and suffering under that section only. Okay. So now we're going to move on, and we're going to talk about more specifically what is a sex crime, what we look for, because I mean a lot of people have different ideas. They think, okay, I've been raped, and they're talking about stuff, and you're like, okay, that's not rape, and there's a legal definition, and we'll talk about what kinds of things we look at when we're talking about rape versus oral copulation versus sodomy, right? So sometimes people will say, I've been raped, and it's really what they're describing is oral copulation by force, or sodomy or something like that. So there's a huge problem between what's out there in the community and what the legal definition is. Okay, so every sex crime, whether you're talking about a child case or an adult case, requires some sort of physical act. Okay. And it also requires usually some sort of sexual act. It can be touching in certain cases, and it could be just an attempt to touch somebody, right? But you're required to prove a physical act, not just what's on somebody's mind. And you're also required that there be no consent. Okay? Now, in some situations, the party may not be legally able to consent regardless. So someone who's 10 years old cannot consent to having sex with an adult or anybody, right? There's things, or somebody who is mentally disabled may not be legally able to give consent. So you need a physical act and you need a lack of consent for a sexual crime. So what kinds of things gets us to the no consent part? Well, there may not have been an agreement that is freely and the victim did not freely and voluntarily agree to the physical act or touching, or had the knowledge that there was some kind of sexual touching going on. Okay, so that may be kind of weird. Like, okay, what's an example of that? Someone who's unconscious may not be knowledgeable that there's like touching going on. Sometimes we have people who go to the doctor's office and maybe it's a chiropractor and the doctor's like, oh, I'm going to check for cancer, and then they're doing these sexual contacts, and we have cases like that. So somebody like that may agree thinking they're going in for a checkup, but in reality they're not consenting to the sex crime. Okay? And then the other lack of consent is when you're unable to give consent, which is either by intoxication, you're unconscious, or because you're too young. Okay? Any questions about that? Okay. Once you've established that you have a physical act or touching and no consent, so you have a sex crime, the next step is to see, okay, when did this happen, right? Because if it happened many, many years ago, we may be unable to prosecute, okay? Now this area is changing, we'll talk about that in a little bit, but let me just kind of give the background, which is, the idea is we can't go back 50 years and prosecute something that happened 50 years ago because we don't have enough evidence, there might not be witnesses. And it might not be fair for the legal process to, someone who's accused of a crime to go back 50 years to try to defend himself or herself. Okay, so that's called the statute of limitations. Typically, the statute of limitations for sex crimes is 10 years. Okay, although that's just changed. Okay, so now it's still 10 years, but if it's a crime that happened more than 10 years ago, there's exceptions, right? The exception is, there's many exceptions, so I hate to generalize statute of limitations, but just understand that they changed the law where now we can, in some cases, we can go back as far as 40 years. As long as it was a minor at the time who was sexually assaulted or victimized, and as long as there was substantial sexual contact. So touching is not enough. Maybe we didn't know who it was, and now we've identified the person through DNA, that can be an exception. So there's all these exceptions to this statute of limitations rule, but I kind of want to just have you think about what we're looking at when we're looking at a case, okay? So for having sex with a minor, it's a lesser crime. That could be consensual sex between, a 14-year-old and a 27-year-old. That's going to be a 3-year statute of limitations, and for misdemeanors, it's always 1 year. There might be some exceptions to that. So what extends beyond the 10 years? How do we go beyond 10 years? It's usually maybe now the DNA has identified the perpetrator, or maybe we have a case where the person is looking at life. So for example, murder has no statute of limitations because you can be sentenced to life if you commit murder. So anything where you have a statute, where you have life, you're not going to have a statute of limitations problem. So be aware of those exceptions as well. Any questions about that?
When, let's say it's 10 years and they go to court, you have to follow the laws that were in place at the time of the crime? Or
To prove the elements of the crime, yes. But for the statute of limitations, we might change the law now and be able to go back to a time where maybe 10 years ago, we couldn't go back that far. Is that kind of where you're going? So,
Like, let's say, something has a 1 to 3 year penalty, but then in 5 years, like when the act happened, when the rape happened, let's say it's 1 to 3 years. And then 7 years down the road, it ends up being a 10-year minimum. Do they get tried on the 10-year minimum, or would they get tried on the, what it was at the time of the action?
it is what it was at the time of the action most of the time. Because you can't, so let's say you have a crime, and I can't think of one off the top of my head, but let's say that something maybe in the 80s was punishable by 7 years, and now it's punishable by life, and somehow we get through that, statute of limitations issue, that we can't go back that far, then we would have to, the maximum that the person could be sentenced to would be the maximum at that time, okay? I don't think there's any exceptions to that, but we usually have to prosecute within the time, for whatever that time frame is. So for example, we have cases where, the law changed several times between, in 2009, 2011, and then it went back to 2009, but if the crime falls within that, those 2 years when the law was one way, before it was how it is now, we have to sentence, and we have to go by the guidelines for that year. Yeah?
I was just gonna mention that that's true for most criminal justice stuff. It's gonna be within the time range. Sentencing will be based off of what the laws were then. I think that the only time that can possibly change is if you could get a retrial, right?
Yeah.
Yeah.
You can get a retrial, or maybe you have a situation that when they passed the law, they said, okay, this is gonna be true for all cases going all the way back. But I don't believe, and
Usually that's not the case.
yeah, they wouldn't, they usually, when they change the law for sentencing, they'll say from starting January 1st of this year on, they won't go back and do it retroactively or something, because then you're violating the due process right of the defendant, and it's just not gonna happen that way. You're gonna go off of the sentencing guideline for that year.
Let's say you want to prosecute or whatever the person that, it's something that happened many years ago, and you want to what is it called? Sorry, I'm so
Prosecute?
It's something let's say someone was molested 15 years ago, and you want to take him to trial or take him to court. What kind of evidence would you be able to bring up, because it's so long ago?
Okay, so we'll talk about that, we're gonna get to that, but that's a good question, and that's the problem with these statute of limitations. So, for example, right now they just should change the law to 40 years. Okay, that sounds great when they pass the law, but the reality is gonna be, how many cases can you go back 40 years later and try to find enough evidence that's gonna convince the jury beyond a reasonable doubt? I mean, I'm sure there's situations that will happen.
Unless there's other victims.
Right, I mean, there's gonna be those situations, but I would hate that people have this idea that we're gonna start prosecuting all these cases all of a sudden, because there's only so much we can prove 40 years later. But, we'll see, it really depends on what the case is. But we'll talk about your question, if you can hold off, I'm gonna get to it. Okay. So, generally, the cases we prosecute are forcible rape cases. That's a violation of Penal Code Section 261A2. You don't have to memorize that number, just know that that means forcible rape, okay? For forcible rape, you have to have a penis go inside a vagina, okay? So, when you hear, the penis touch me here or here, if it does not go, if you cannot prove penetration or articulate penetration, maybe you're not sure, I'm not sure if it went in, or maybe children cannot articulate whether the penis went inside or not. That's always a big issue. So when I tell you that, we kind of have to go into this area, it might be embarrassing to say, okay, sometimes they'll say that, the penis only went in a little bit, or just the tip, okay? That's all that we need. But we have to have the penis go inside a vagina for forcible rape, okay? So be aware of that, because people don't know that, and they think rape is something, it encompasses all sexual assault, but it doesn't. This is very specific. ejaculation is not required. So let's say a child or a victim says the penis, just the tip went in for a second. Is that a completed crime?
Yes.
Yeah, because all you have to do is prove penetration, right? You don't have to have ejaculation or anything like that. Any penetration, as long as we have some, is enough. And that the victim does not consent. So you have penetration without consent and by use of force. And again, accomplished by force, violence, or fear. So sometimes the victim will say, well, I was scared and I froze and I didn't move or something like that. That's enough for a forcible rape because as long as the penetration is accomplished by force or fear, then we've proven forcible rape. Okay? So how is the rape charge going to be attacked by the defense? Well, one of the big ways is to say, well, the victim asked for a condom to be used. Or she just laid there and didn't resist and didn't fight and didn't kick. Okay, those are typical defenses that we hear every single day. That's not required under the law. You're not required to prove that the victim kicked or screamed for help, right? That's not required under the law. It'd be great if we have it, but it's not required. And most of the time, you're not going to have someone who's going to scream and kick and punch and all that stuff. I have had cases where the victim says, hey, put on a condom. That alone, the victim asking for that does not mean that she's consenting, right? Because of fear of AIDS or whatever the case might be, maybe that's why she's asking for the condom. Many times you have a victim that may have had a sexual relationship with the defendant, but on this occasion did not consent and force or fear was used. So just because they dated before, had sex before, it does not matter, right? You have two married people, and there can still be forcible rape. Same thing if you have a dating relationship. And obviously that's always going to be your defense, that because they had sex before, she consented this time. That's not necessarily the case. Silence, right? Not screaming doesn't mean she's agreeing to it. I should be careful. We also have male victims, so if I use the she and not the he, it's for both, okay? This one is very common, especially in intoxication cases where the victim goes and kisses and maybe, there's some consensual stuff going on, and then all of a sudden says, hey, you know what, I don't want to do it anymore, I'm done. And then then there's force or fear used, you still have rape, right? Because consent to one act, maybe I consented to oral copulation, but I'm not consenting to penetration of the vagina by penis, right? So that's that does not mean there's consent, right, necessarily. But again, we're looking at everything that happened, right? The totality of the facts to determine whether or not we can file this charge. And then this last one, if the defendant says, well, she wanted it or she consented to it, but does not have but a person in the same situation would not reasonably believe that the person is consenting, you don't have consent either. The person can't just say, well, I thought she was into it, right? It's whatever the reasonable person, right? What most people would say, yeah, okay, someone in that situation would know that the person's not consenting. Okay? So your three elements, when we talk about elements, are for rape, penetration of vagina with penis, without consent by force or fear. That's rape.
So what about when it's a man?
Okay, great question. Okay, so we'll get to that. And the force doesn't have to be punching and where the person's bruised. It's any force to overcome the will of the person by force or fear. So what happens when it's a man? Okay, so you do have sexual assault. You can have a man on man, woman on woman, You know, you can have the woman be the perpetrator against the man, right? But for a forcible rape, you have to have a penis inside the vagina, okay? If you have a forcible assault, a sexual assault, male on male, then typically we're looking at sodomy by force, or forcible oral copulation, or some sort of sexual assault, okay?
Thank you.
Do you understand why that is? Because under the legal definition of rape, there has to be a penis and vagina. If you have male assaulting another male, you're gonna have a different completed sexual act.
Do they hold the same, like, legal penalties?
Yeah.
Okay.
So it's the same legal penalty and it's the same idea. You're gonna have an act, you're gonna have no consent, you're gonna have force or fear, but you're not calling it rape.
Okay.
Do you know what I mean? And believe it or not, under the legal definition of rape, there's still the definition that it has to be two people that are not married, right? Like, because the element back then, when this charge has been on the books for a long time, you still are required to show that they're not married under the legal definition, but it's just, you know, that's just from, because the charge has been there for a long time.
Yeah, that was because the sentencing was different. When we had talked about this the first day of class, the sentencing used to be different because your wife was your property.
Yeah.
But California is one of the states where it will be charged the same way, right? So the sentencing will be the same for a spouse as it would be for somebody who wasn't the spouse. Not true for all states.
And it's the same, again, if it's male on male, female on female, and, you know, it's the same, it's just called different things, okay? But be aware, when your victim's telling you, hey, I've been raped, and they think that there's gonna be a rape charge, and then you're like, well, actually, it's not a rape charge, it's something else. So I use the generic term of sexual assault when I'm talking in general, unless I'm talking specifically about what the legal, whatever the legal definition is of that crime.
The brief definition that we have from the notes from our first session says that it's an act of sexual intercourse by any object.
Yeah, so let
So
me,
not-
let me talk about that. So let's say you have penetration of the vagina by, I don't know, it could be anything, it could be a tool, it could be, you know, any object, okay? Then that's rape, by foreign object. That's a different charge than rape by force or fear. So that's a different section. It might have a different minimum maximum, and the elements are different. I don't know if I have it in this PowerPoint, but it's still a sexual crime, and there's still penetration of the vagina, and instead of the penis, it's whatever the object is. It could be, you know, a knife or whatever it is, right? And it would just be a different number, and the elements would be almost identical, except that last part would be, instead of penetration by penis, it would be penetration by object, okay? Sometimes the object is unknown, and that's actually very common. You know, you have a woman who's gonna say it was dark, I think he went in with it with penis, I'm not really sure what it was, I felt something. Very, very common, okay? And there's actually a rape there's rape by an unknown object charge, okay? So rape of an unknown object, rape of a foreign object, and rape by force or fear are three different charges and have three different legal definitions, but we might have a victim who says it's all the same, it's all rape, right, to that person. Same thing, rape of an intoxicated victim, same elements, right? Penetration of vagina by penis. But this time the consent is not there because of the controlling substance or intoxicating controlled substance, okay? So that prevented the victim from resisting. That's how it's defined. Which I think is interesting because on forcible rape, the victim doesn't have to resist. In this charge, the victim is unable to resist. And in my mind, I think we still need to make some changes here, but that's maybe for the legislature to deal with. But here, she could not resist because of the controlling substance. In a forcible rape, she doesn't have to resist, and that's why I don't like how we define rape of an intoxicated victim right now, but until that changes, that's our element. So she was too intoxicated to exercise reasonable judgment, doesn't understand what's going on. And the perpetrator knew or should have known that the person could not consent. Okay? This is the part that most people forget about in the media or the victim. We have to prove that the victim knew or should have known that she was too intoxicated to resist. And this is a very controversial part of the elements, but it's still on the books. I still have to prove what was on the defendant's mind at the time, right? So what's your common defense right here with this element? What's your number one common defense? I was drunk, I didn't know, I was passed out, I blacked out, I thought she wanted it, right? He said, she said, it's your typical he said, she said, and that's why these cases are so hard to prove. Because we're always going to have to show to a jury beyond a reasonable doubt that he knew or should have known under a reasonable person standard that she could not consent. And when you have a situation where both people are drinking, all the defendant has to do is take the stand and say, I was totally wasted, I had 10 beers or whatever it is, I couldn't tell, right? But we're slowly changing that, we're getting there, it's gonna take time, but we're trying. Rape of an unconscious victim, same thing. A little bit slightly different element. Penetration vaginal penis, same elements. The victim cannot resist because she was unconscious. So she was asleep, unconscious, not aware, and the perpetrator knew she could not resist because she was unconscious. Let me show you what this can look like. Okay? This is what a jury, this is going to go really fast, but this is what a jury thinks of when we talk about rape of an unconscious person. See that? Let me do it one more time. It's very, very fast. What was that? Okay, ready? Okay. Real case. Let me tell you what the facts are, just to give you some background, okay? Young woman has a friend, they go out drinking, she meets him at a bus stop, they drink, I think, a whole bottle of vodka, I forget what the alcohol was. But she was highly intoxicated, and he was drinking with her, they've known each other for some time. And someone going on a bike, going by, that's why you see that video clip like that, because the person's just going down the street on a bike at night, and this is what he sees. And then goes back and takes a video of it, because he's, it's one of those things like, okay, what did I just see? So the witness called the police. Police arrive, and they talk. Oh, before he calls the police, the guy that was on her says, hey, we're cool, she's my girlfriend. Okay? We're cool, she's my girlfriend, we're good. So the guy, seeing her condition, obviously she's passed out unconscious, calls the police arrive. He tells the cops the same thing, hey, she's into it, we're both drinking, she's my, we're hooking up, whatever the case might be, that's the story. They wake her up, and what does she say? I didn't have sex with him, what are you talking about? No, he didn't rape me. What are you talking about? He's not raping me, he's my friend. And she's so drunk that she becomes belligerent with the cops. She's like, F you, and she's belligerent with the cops, and she swears up and down that they didn't have sex and that and she denies being raped. She refused to go to a sexual assault examination. It was so bad the cops took her home because they didn't know what else to do with her. And luckily, you had that witness that had that video. So when you first see these reports, I get the reports and he's arrested immediately, and I'm like, wait, she says she wasn't raped, and he says it was a girlfriend, it was consensual. How am I going to prove this, right? Until you see this 5-second video. How fast do you think this guy took a deal? Right? No question. And the victim, even in court, she refused to come and do the pre-filing interview. She swore up and down that no rape occurred, okay? So this is what unconscious looks like in some cases, and factually, maybe if we don't have a video or something like that, we might just read these facts and be like, okay, we can't prove this.
See the video?
I didn't show her the video because I didn't want to have that emotional impact on her. So I just told her we had enough evidence and, referred her to counseling because I think that would have been very hard for her to have seen that, and I'm not equipped to be that person, right? So, but he was convicted, so she didn't have to testify and she didn't have to do any of that.
I have a question. It is a different scenario, but just wanted to know. What happens when it's a person that's deceased? Because I've heard that they also, so what happens there with the?
Right, if somebody's having sex with a corpse, that is a crime. And typically on those cases, if we are able to have some evidence, and usually that's by way of evidence of, witnesses or maybe some surveillance video, but also physical evidence. If you have DNA that you can show that maybe there's some sperm on this dead body. I mean, there's ways that we can try that we have been able to prove that this has occurred. So that would be a different charge than rape by force of fear, because force of fear, I have to prove that the person was not consenting, was afraid, or there was force, and if the person's dead, you can't prove that. So that would be a separate sexual charge. Do you understand?
Yeah.
They're very specific, these charges. So we have to know exactly what happened to find the right charge that fits.
Would the sentencing be as strong as if the person were alive?
I think so. For sure, they would have to register as a sex offender. I don't know off the top of my head we don't get a lot of those cases.
Yeah.
I've never had one of those cases, but I know that we have had those
Yeah.
cases. So I don't know what the sentence is, but I can look into it for you.
Thank you.
I read somewhere that this girl was on a dating app, and she went out to go meet up with this guy, and they were dating for a while, and they ended up having sex. But then she went to go get herself checked, and she had maggots inside her, or something weird in there, and they told her you could only get this if you have sex with a dead body. And so she looked up the guy on Facebook, and he works at a mortuary or something like that. So can she press charges on him?
Of course.
Oh, okay.
Because she's unaware, right?
Yeah,
So I would definitely encourage her to
yeah.
report that, because maybe they can find evidence of what was happening. It's so weird that there's so many people asking about that. But I would definitely encourage you to tell that person to report, okay? And maybe they could do surveillance, they could find what's happening. I mean, obviously it sounds really bizarre, but anyway, crazy. Now, this world is a crazy place, and unfortunately, I'm not surprised by anything anymore. I'm just at that point. So yeah, I mean, that person's definitely unaware or unconscious. Maybe this is one of those examples. There was prior consent, and there was a consensual relationship, but this would be something she didn't consent to. I think that would be more along the unconscious, but I'd have to figure out more how did she find out what happened? Did she have an injury?
Yeah.
Now that she has this evidence, how can we prove it? At least report it. You never know. Okay, so we talked about this. Can we go forward? Okay. Sodomy. Okay, so this is where you can have male on female, male on male. You could have penetration of the anus by foreign object, you could have penetration of the anus by an unknown object, that could include a penis, but you're not really sure, okay? So here you have penetration, however slight, same definition. Ejaculation is not required, slight penetration is enough, you don't have to show full-on penetration, a little tip is sufficient, there's no consent, same thing, by force of fear. Person could have been intoxicated, unconscious, right? It could be either way, either the perpetrator inserts the penis in the anus or the other way around, as long as we can show that the other person did it because of force of fear, right? It can go either way. So in that case, most people would say, okay, that's rape, but it's really sodomy. Oral copulation, so any contact with the mouth, with the genitalia, it could be the penis, vagina, or anus. Same thing, ejaculation is not required. Penetration is not required, so any touching of the lips. Sometimes the victims will say, I clenched my mouth, so he wouldn't put the penis inside my mouth, like that. As long as the penis touches the mouth, that's enough for a completed oral copulation. We don't have, it's not like the other one where you have to show penetration. Here, any contact with the mouth is enough. There's no consent. By force of fear, intoxication, or because he or she was unconscious. So it could be also a forcible oral copulation, or oral copulation of an intoxicated person. And this one could be male, male, female, female. And you know, it could go either way, but we have to have this, and it could go either way as well. Sexual penetration. This is the part, the sexual penetration by a foreign object, by a penis. Let's see if it's in there. By foreign or unknown object, substance, device, anything can, as long as there's penetration there. Any body part, could be a finger, right, inside the anus or anything like that. Penis could be also used for discharge if you're not sure. This is where I think it was a penis, but I'm not really sure, that kind of stuff. So you don't have to show that, as long as you can show that that the person acted with the intent to cause pain, injury, or discomfort. And you don't have to actually arouse, or the person doesn't have to ejaculate, but he has to act with the intent. Like the penetration is done with the intent to arouse the other person. So if the person's putting their finger in the vagina, you have to show that he intended to do that to arouse the person or gratify them sexually. So you could even have penetration on another person, as long as you're doing it by force or fear or threats, like you have to put your finger on somebody else, right? And you're only doing it not because you're consenting, but you're doing it out of some sort of force or fear. Okay, so those are kind of our big ticket stuff, right? Felony, big ticket crimes. So now we're moving kind of down we're down in the order of behavior, I guess. So a sexual battery, it can be a felony, it could also be a misdemeanor. This is what we call a wobbler. It could be charged one way or the other. And this is just contact with your breast, your butt, your penis. Okay? As long as you can show it's against the will of the person and or some sort of sexual gratification, wasn't by accident, you touched someone's boobs or something like that. And like I said, it's a wobbler. So what kinds of things would we look for to make it a felony? So we look for maybe like the person was held and then touched, or skin to skin, right? So over clothing might be a misdemeanor. Touching skin to skin is a felony. Or you might have a victim that's institutionalized or is incapacitated in some way, or is unconscious of the nature of the act. Or that the defender or the suspect fraudulently represented that the touching was for a professional purpose. So these are your doctor type cases or your chiropractors or your massage therapists, we get that a lot, where someone goes in for a massage or a chiropractor, and, you know, there's some massages that include the inserting of the finger to massage some of the, some of the muscles back there. I don't know, but it is a thing, actually. I didn't know. And so, but if the person consents because they think that that's, you know, for some other purpose, but then realizes, oh no, I've been assaulted, you have this charge for those types of situations. And the reason that would be a felonious is because it's such a violation of trust and confidence, so that makes it more egregious than a misdemeanor conduct. And then now we move down to our statutory sex cases. These are the ones where you have consensual sex between, you know, two people, but one is a minor or someone can consent. As long as they're under 18, the person's over 18, there's more than 3 years difference, right? In these cases, because the punishment's not as severe, it doesn't matter if they consent or not. I mean, we get a lot of these cases, and most of these now are probably, they never really go to court. They're very, very easy to prove, you know. Yes, she's in love. Yes, she wanted, you know, yes, you know, she threw herself on you. It doesn't matter, it's illegal, you're done, okay? But this one does not require sexual registration.
What's the minimum, time served or prosecution?
Well, this could be a misdemeanor. We can, it's a wobbler, it could be a misdemeanor, it's not, usually it's like some jail time, you know, probation, type of stuff. Okay. Other sex-related crimes, okay. So, there's a whole laundry list of acts. Remember I told you we have to look at what the facts are, and then we look for the charge. So there's all kinds of stuff that are sex-related that come under the umbrella. So our newest is revenge porn. That's where someone like puts something on the internet and you're naked or you're having sex with that person. It's called revenge porn. It's a misdemeanor. I don't know if we're prosecuting a lot of these cases, but this just recently passed. I wouldn't get this case because it's a misdemeanor. So if you get a city attorney, ask them what they're doing with these cases. Yeah.
Question. For the revenge porn, is it, I guess, is it seen a lot in the military? Because I know that just recently, there was this big scandal with, you know, the military personnel putting up pictures of, you know, females naked or, you know, some sort of way
Yeah.
on the internet.
I don't know. We don't get a lot of military cases because most of them do happen on base, and we don't live in the San Diego area. So I don't get a lot of those misdemeanor, I don't get any misdemeanor cases, and I don't have any case like that. I've seen one, but it doesn't mean they don't happen. I don't really know.
So would it happen out here? So let's say there was, you know, someone in the military who's putting out revenge porn of, you know, like, for example, like
I'm not military.
someone, you're not military. And she
It would
was to
still be a
report it.
crime if she reports it, but I don't know, how well we're doing. I don't know, because I don't know what the percentage, I don't know how many of these cases there are, to be honest with you. I don't do misdemeanors, so I can't tell you from my personal experience how many of these we're actually filing or how many we're prosecuting, but it's out there. It just recently passed. It hasn't been on the books that long.
What if you can't find out who is putting up those pictures or videos?
Well, hopefully, they, you know, like, they have the ability to find, at least that through IP addresses. Maybe they can identify the perpetrator. It's usually something like this, you know who the person is. It's known to the victim, but again, I'm not really, there are ways, I just wouldn't know how to tell you what the success rate is. 'Cause I don't
And do you
really-
charge like kids in high school? Because I remember in high school I would get forwards of like girls and guys all the time.
We
Kids-
could,
kids
but
are so
if it's,
specific.
but if it's a crime in high school, they're minors, okay? So anytime you have perpetrators that are minors, they're not prosecuted in adult court, they're prosecuted in, you know, in
Juvenile.
juvenile court. In juvenile court on something like that, you know, they're not, juvenile court is not, I mean, it's not the same as adult. The idea in juvenile court is that they can be rehabilitated. Most of the time they get home on probation, you know, things like that, so I don't know how severe the punishment is, because I don't do juvenile court, it's been a long time since I was in juvenile court, but if it's a high school or junior high type situation, it would be handled by the juvenile court. It's still against the law, and it would still have to be looked at, I'm just not sure what this punishment would be.
Would it still be on the record for life or?
That's a great question. Juveniles who are accused in juvenile court have a right to have their records sealed. After they complete, let's say they've been convicted, they can seal it. So sometimes we don't see it on the rap sheet, right? But sometimes we do. So it depends on whether or not that juvenile has gone through the process of sealing their juvenile record. And,
So, cause I know there's some jobs that require background check. Since it's sealed, would it come up?
It depends. So we've had juvenile cases where there are juvenile convictions where we see it in the rap and it would come up, especially if they're serious or violent felonies. Those would probably at least be shown, even if you don't know what the outcome is. In some cases, they are sealed, so we don't really see it on the rap sheet. It's really a case-by-case basis. Some kids are smart or have good attorneys, and they tell them they seal it for them, and others, you know, just kind of are part of that, you know, process, and you can see it. So it's hard to give you an answer on that.
Thank you.
Okay. Indecent exposure, you just have to have exposure of the genitalia. It could be it's a misdemeanor crime, you know, these are the flashers. But if they do it more than once and they get convicted and then they do it again, then they're looking at felony time, okay? So I prosecuted a guy that's been caught 2 or 3 times, right? And unfortunately, the judge kept out the fact that he had been convicted of a 314 before, so we could only go off of like the current 314, and the jury hung. And I just wanted to pull my hair out, because if the jury knew that this is what this guy does, he would have been prosecuted, he would have been convicted as a felony.
Why
So-
did he keep it out?
the judge felt that it was not fair, that the jury should judge just this act, whether or not this act, that there's enough evidence for this particular act. So it's in the discretion of the court when we talk about being able to tell the jury about past crimes. It's always under the discretion of the court. So the court could have a guy who's had prior rape convictions, and the court could exclude those prior rape convictions if they want to. It's under the discretionary, their discretion power, I guess. So in that case, it was filed as a felony, we ended up giving him a misdemeanor in that case. But it didn't matter because he was already a sexual registrant, he had already been convicted, and it's just a matter of time when he does it again. Okay, so 220. This is the assault with intent to commit rape, okay? So this is a great tool for us when we have a situation where, I think you were describing, someone goes into your house or someone goes up to you and they start like getting at your pants, and maybe they're doing this or they're trying to reach in your pants or something like that, but there's no penetration, something happens, she fights him off and he runs. But that assault, right, is still a crime. Like, you still have a 220. This is a violent charge. You're gonna charge this guy for the violent felony because it's pretty creepy when you're walking down the street and some guy, you know, jumps on top of you and maybe doesn't accomplish the completed act of the penetration of the vagina, but you still know that that's what he wanted. You still know he's going for the pants, he's running, whatever. You can then charge, this is an assault with intent. But it's hard to prove because you have to show to the jury that he intended to raping her, and there was no rape. So it's hard for the jury to understand, like, okay, we're not saying he completed the act, we're just saying that he assaulted with the intent to commit the act. If successful, we get a lot of time under this charge, okay? But it's not that easy to convince the jury on this, okay? So, and the assault, we don't even have to have a touching. You got a person walking down the street, and maybe the guy lunges at her or something, you know, but doesn't actually touch the person. It doesn't matter, as long as you can show that what was on his mind was to rape or orally copulate or whatever the case might be, that victim. And then there's the kidnapping, right, taking maybe a child for the purpose of abusing them or raping them, right? That's also a great charge. That doesn't require an actual penetration or actual rape, but it's the kidnapping with the intent to rape. That's our 209. That's a great charge. That's almost, I think that could be a life, actually. Yes.
So is that something where, like, they could be charged with, like, bad and rape and, okay.
Yeah. So let's say a woman's walking down the street. Guy comes and gets her in the car. And then drives somewhere and then rapes her. That guy would be charged with the kidnap with intent to commit rape and the rape. Okay. Oh my gosh, okay. So when you're talking, I try really, this is so much easier said than done, because our natural instinct is to say, okay, well, did you fight him off? Why didn't you fight him off? Or why didn't you scream? You know, why did you wait a year to report this? I mean, the why is hard on our victim, because believe me, she's asked herself probably, or he's asked himself 1,000 times that same question. But it's something that jurors want to know, so we have to kind of have this information, because I have to explain, like, okay, when somebody waits 10 years to report, I need to know why, so then I could explain to the court, okay, the reason she didn't report is because she was afraid, or, you know, I have to give that jury that explanation somehow. So we're going to have to ask these questions, but we have to be careful of how we ask that question. So, you know, stop, consider your questions. Okay. And the idea here is, you know, there's probably better ways of asking the same question. So you can say, okay, so what made you now come forward and make this report? Or when that was happening, what was going through your mind? You know, you get some great answers that way. So just be aware of that. It's a lot easier said than done. I've caught myself maybe asking that question, maybe not the best way, and it's just something we always have to be aware of. And I'm sure you guys get trained on that all the time. Sentencing, okay. We're going to talk briefly about this. Okay, so our misdemeanors, up to 1 year in county jail, okay? Our basic crimes, right, our 288As, our basic rapes, they're mostly 3, 6, or 8, unless there's these factors we talked about, which are the strikes. Maybe the person has been convicted of, has 2 strikes and now commits another rape. Well, now this guy's going to look at 25 years to life because he has 2 strikes. Or if he has 2 strikes prior and they're violent or serious, now we can get 16 years because we would double whatever the sentencing would be because he's got this prior strike. Okay? So again, when we talk about, well, how come some people get 6 months and another person gets life? Like, what is the difference? Well, it depends on the guy's criminal history. It depends on what the facts are. What are the allegations we can make? You know, can we prove he tied and bound and tortured the person, that there's multiple victims, whatever that case might be, to elevate that punishment to a life term. Okay? So that's why you might have different outcomes for similar facts, but that's where we are. Most crimes, you have to serve 85%. So let's say you have someone who has a child molestation, they get 8 years, the max. Are they really going to serve 8 years? No, they're going to serve 85% of those 8 years. They get credit for every day they're in court, for every day they're in jail or in custody. And but because these are violent offenses, most sex crimes are, they'll have to serve at least 85%. Okay? Other types of crimes, like drug crimes or other types of assault, non-sexual, they serve half the time. So maybe like, I don't know, like a burglary, if you get 4 years, you're really going to serve, 50% of the time. Or whatever the other crime might be, a non-violent crime. Okay? Actually, burglary is considered serious, so I have to think, like theft or something like that, okay? Sexual battery, remember this is that wobbler. So if it's charged as a misdemeanor, it's 1 year. If it's charged as a felony, that's 2, 3, or 4 years. You know, we consider, was it skin to skin? Was the person restrained while the person jumped on top of them and touched their boobs? You know, that kind of stuff. That elevates it to a felony, same conduct. Kidnap for rape is life. That's that 209B. Great charge, very serious. Outcome, these are the ones we talked about, sex with a minor. They're also wobblers, it depends, but they're not 290 with registering prior. The assault at 220, the one where you can lunge at a person as long as you can prove that they intended to rape. That's at 220, you get 2, 4, 6. Great charge, but you can still get probation if the facts warrant them, or if you can't prove it, we might go for probation, but at least we can get them registered. Okay, the enhancements. So this is where, who asked that question about the enhancements? So these are all of them. I've talked a little bit about them. So if you use a weapon during a sex crime, that elevates it to a 15 years to life. If you use a weapon and you cause great bodily injury, then now you have 2 factors that elevates it to 25 years to life. If someone's elderly, if you kidnap a victim, now you're looking at, these are the factors that make the rape or the sexual assault much more serious. Okay? Multiple victims gets you that 15 years to life. If you have multiple victims and you have a prior sex conviction, you're looking at 25 years to life per count, per victim. You know, so the numbers add up. Administration of drugs, hard to prove. Huh? It's hard to prove. I don't believe it includes alcohol, because that would make most of our cases eligible for 15 to, I think this is the date rape drugs, which are really, really hard to prove. Any torture, is gonna elevate, those are your enhancements. That elevates your sentencing. So it adds years, it makes it, you know, if you have GBI or elderly, you can add 5 more years, you can convert to an indeterminate term, that's life, right? That just means that you're looking at life, the 1 strike allegation, 15 years to life or 25 years to life. Lifetime sex registration, every year that on their birthday or whenever they move, they have to register with their local law enforcement. If they violate and they don't register, that's a new crime. Although most of the time those are misdemeanors unless you have more than 1 prior conviction. Obviously, if you're a registered sex offender, you can't live near schools or that sort of thing. You're subject to sexually violent predator laws. We have those predators that we know will continue to offend, like, you know, a child molester will keep on doing it. So even after they have completed their crime or their punishment, let's say they were sentenced to 20 years and now they're ready to get out, we can charge them as under the sexual violent predator laws, and then we can keep them civilly committed for 2 years. So then every 2 years we have to go back to court to try to keep them in longer. And that's a big battle right now because in California they're trying to get them to be really, after they serve their punishment, to be released. And so you're hearing on TV like, oh, this sexual violent predator is going to get released to this community, and people are protesting. We're trying to keep them in, but it's up to the court eventually, and there's actually a right to a jury trial for that, and the jury determines whether or not we can keep them in or not. If it takes a long time. And that's for the really, 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 really bad guys, the ones that we know for sure will continue to offend. We have probationary conditions such as, let's say somebody gets probation, they still have to complete sex offender classes, they still have to be subject to polygraph, they always have to pay restitution in every single crime. I won't talk about that. Okay, did I answer your question? What was your question again?
It was if something happened like many years ago.
Okay, yeah,
what can
I
you use
remember.
as evidence?
Yeah, so something like that. Let's say, for example, somebody reported, it wasn't filed on, and then now 10 years later, maybe now we have the DNA has come through and the DNA has found the perpetrator. For example, let's say at the time, 10 years ago, we had a profile, but we didn't know who that profile belonged to. But that profile is entered into CODIS, which is the database for the entire state of California. So if anyone's arrested and they get their DNA, they can compare, oh, this profile is identical to this profile. And now we have somebody who is the perpetrator. That's one example. Another example might be, okay, we didn't file it now, but now we have this other victim who had the same thing happen to her. So now, hey, let's bring back that victim from 20 years ago, or what, if the statute of limitations hasn't run, or there's an exception, and now we can charge the 2 new victims. I have had that situation. I also, even if it happened 20 years ago, and now I have a new victim, and I can't charge this victim because it's out of statute, I can still bring that victim in to testify if the judge allows it as an 1108 victim, which is to show the jury this is the guy that commits rape. Really, I mean, it just depends, maybe that person is really compelling, and bottom line, in a sex crimes case, you don't have to have anything to corroborate under the law, but under policy, you must have some corroboration. And why is that? A victim can come and testify in court, and if the jury believes that victim and believes that all the elements have been proven, that person can get convicted on the testimony of one person, okay? And that's what the law says. Now, is that the reality? Is it realistic that jurors are gonna just go off of, the testimony of one person? Usually not. It's very hard, right? That usually doesn't happen. So we try to look for anything that might help, but if that person's compelling, I have had cases where that's pretty much all I've got. Do you know what I mean? It just really depends. Okay, yes. One question.
So if, let's say there's a victim and she's getting assaulted, she's being raped or whatever, or she's witnessing, her child being raped, and she attacked the perpetrator and killed the perpetrator, would the same law apply to, the woman defending herself or her child or someone she loves? Would she get arrested and convicted?
So on that, it would be investigated. You have a right to defend yourself or someone you love from, immediate harm or life-threatening harm or something like that. So obviously that would be looked at, and if they find that that person truly was acting in the interest of protecting herself or a victim, they would not charge that victim, but that would be investigated. So it really depends on what the facts are in that case. Any other questions? It's 9:30. I'm so sorry.
No, everything that you had to say was super
That's
important, so
fantastic.
thank you. Anything else that you guys want to ask Gloria?